the concept of law affecting employment. Okay? I will be discussing with you the general concept of law affecting employment. And when we speak of employment, my guide or your guide to employment is the Philippine Labor Code. Okay? Hatiin natin yung Labor Code into two sections. Actually, 3 kasi ito. Yung classification ito 3. Pero with regard to this lecture and with regard to your subject matter, hahatiin natin sa 3. So, the first classification is the labor standard laws. Ang labor standard laws basically is those that provide for the pay and other legal benefits to which the worker, while at work, is entitled to receive from his employer. Then yung first classification natin, labor standards ang tawag doon. Yung second is the labor relations law. Yung labor relation laws, ito yung those intended to stabilize the relations of employees and their employers, adjust differences between them through collective bargaining, and settle labor disputes through conciliation, mediation, and arbitration. The second one, which is the labor relations laws, I will be discussing it with you pero in simplified form. Kasi basically ito ay pang lawyers na dapat to. Okay? Pero yung labor standards, ito yung uunahin nating i-discuss. Medyo interesting to para sa inyo, lalo na after your graduation and you intend to work sa mga kumpanya, you should understand labor standards. Okay? At yung sinasabi kong third classification is yung welfare legislation. Those that require payment of benefits by government agencies to the worker or his family while he cannot work by reason of sickness, disability, old age, death, and similar hazards. We will not touch that unless madadaanan ko. Okay? Madadaanan ko through my lecture. Now, we start with labor standards. Of course, before we start with labor standards, you have to determine whether there exists an employer-employee relationship. Importante ito. Because without an employer-employee relationship, then there is no employment to speak of. Tatandaan yan, wala kayong pag-uusapan na employment kung walang employer-employee relationship. So, the basic premise of employer-employee relationship, if you can answer all the questions with an answer na yes. Okay? Pag ang sagot dito ay yes sa lahat ng tanong, then there exists an employer-employee relationship. Ano yon? So, ito yung mga tanong. Ito rin yung mga elements. Kaya siya, ang title niyan, Test of Employer-Employee Relationship. Una, is there a selection and engagement of the employee? Yung employer ba ang namili at nag-engage dun sa employee para magtrabaho? That's the first question. The second question is payment of wages. Siya ba ang nagbabayad ng wages? Number 2, kung siya ang pumili, yung power of selection, dapat may power of dismissal din siya. At kung meron siyang power of dismissal, then of course yes yun. So 3 doon nasagot na kagad ng yes. Ang usually nagkakaroon ng problema ay yung tinatawag nating power of control. Okay? Ito yung pinaka-importante because the power of control is the most important index in the existence of employer-employee relationship. It is the so-called control test. And that is whether the employer controls or has reserved the right to control the employee not only as to the result of the work to be done, but also as to the means and methods by which the same is to be accomplished. Okay, yung power. Sinasabi sa iyo ng empleyado kung anong dapat, ng employer, kung anong dapat mong gawin, kung ano ang paraan ng iyong paggawa. Plus, as I have discussed, di ba, yung ating decision ng Supreme Court as to the definition of a certain words, sila yung nagde-define. Ito yun. Okay? Sabi sa kaso ng Investment Planning Corporation of the Philippines versus Social Security System, ito yung work to be done but also the means and methods by which it is to be accomplished. Same in the case of Felicilda Uy versus NLRC wherein sabi rin ng Supreme Court doon ay hindi lang yung dapat control, okay? Yung total control. Pwede rin i-consider yung supervision. Kasi dito sa kasong ito, yung truck driver, sabi niya, sabi nung employer, hindi ko naman sinasabi kung anong oras siya magda-drive. Sabi naman ng driver, kahit na hindi mo sinasabi kung anong oras ako magda-drive, sinasabi mo naman kung saan ako pupunta. Sana ano ang gagawin ko, sino ang dideliveran ko. So, the Supreme Court in that case also held that it is tantamount or it is equivalent to power of control. So, kung duda kayo, sagutin lang ng yes lahat ito, then there is already an employer-employee relationship. Okay? Now, kung meron na, i-define muna natin isa-isa. Ano ba ibig sabihin ng project employee, contractual employee, seasonal employee, at saka apprenticeship? Pag sinabi mong project employees, ito yung are employed in connection with a particular construction project. Kadalasan ito, class, sa mga construction to. The employment has been fixed for a specific project or undertaking, the completion or termination of which has been determined at the time of the engagement of the employee. Kaya ko lang sinishare sa inyo to, class, it's because this is a project employees, kasi baka pwedeng mangyari sa inyo, lalo na sa tourism, and yung tourism nyo, halimbawa, may project ang Department of Tourism o kung province of Pampanga, kinuha kayo for a certain project, then technically speaking, project employee kayo. So, may duration lang yung time na yon. Pwedeng 1 year lang. Kasi, kung dadaan tayo dun sa mamaya, maintindihan nyo yung probationary period pag in-explain ko. Pero, yung project employee, may certain period lang yan. May undertaking. Pero, specific ang project. Okay? Ano naman yung contractual employee? Yung contractual employee includes one employed by a contractor or subcontractor to perform or complete a job, work, or service pursuant to an agreement between the latter and a principal. Ito yung based dun sa contract lang. Okay? Na meron ang isang contractor din or subcontractor to perform or complete a job, work, or service. Okay? Based to sa agreement. So, dapat nakalagay yon, nakasulat. So, ano naman ang seasonal employees? Seasonal employees where the work or service to be performed is seasonal in character. The employment is deemed to last only for the duration of the season. However, seasonal employees who are consistently rehired after every season are considered merely leave of absence with pay. Their employment relationship is not severed but only suspended. As such, they are considered in regular employment. Class, ito yung dito dinidistinguish. Okay? Pero kung inyong tututukan lang kung ano yung seasonal employees, ito yung where the work or service to be performed is seasonal in character. Kadalasan dito, class, yun yung mga tinatawag na empleyado na, halimbawa, pag summer lang, malakas. Or, kung alam niyo yung, ano nga ba yun? Splash Island, kunyari. Yung Splash Island, class, malakas na malakas lang to pag summer. So, ang ginagawa ng management, nag-hire sila ng mga empleyado during the season lang na malakas sila. Kasi pag tag-ulan, mahina naman to eh. So, hindi naman ganun kadami yung kanilang visitors or guests. So, pwede rin yun. Kasi otherwise, pag sila ay parating nire-rehire, Okay? So, ang tawag na doon, regular employment. Iba na ang benepisyo ng mga regular employee. Now, ano naman yung apprenticeship? Pag sinabi mong apprentice, ito yung worker who is covered by a written apprenticeship agreement with an individual employer or any of the entities recognized by the labor code in an approved apprenticeshable occupation. Tatandaan nyo, pag kinuha kayong apprentice, sabihin nyo, meron ba kayong papel na ina-approvean kayo ng labor code na kayo ay pwedeng tumanggap ng apprentice? Yun ang number one. Ngayon, ano yung apprenticeship? It means practical training on the job, supplemented by a related theoretical instruction involving apprenticeshable occupations and trades as may be approved by the Secretary of Labor and Employment. Tandaan nyo, class, ang apprenticeship, dito may kasamang lecture, may kasamang pagtuturo. Hindi lang basta-basta trabaho. Kaya nga may mga condition dito. The employer is engaged in a highly technical industry and the apprentice is employed as an apprenticeshable occupation. Okay? Dapat highly technical. Yan yung mga sinasabi nating Silicon Valley. Siyempre, highly technical yun. Bukod doon, marami pa naman. Ito yung mga industries engaged in the application of advanced technology. Okay? So, dinidefine ko lang isa-isa to para mas madali nyong maintindihan. Now, we go to probationary employment. Kasi class, itong probationary employment, dito madalas nagkakatalo. According to Article 281 of the Labor Code, probationary employment shall not exceed 6 months from the date the employee started working unless it is covered by an apprenticeship agreement stipulating a longer period. So, very clear ang batas, class. Dapat shall not exceed 6 months. Okay? The services of an employee who has been engaged on a probationary basis may be terminated for a just cause or when he fails to qualify as a regular employee in accordance with reasonable standards made known by the employer to employee at the time of his engagement. An employee who is allowed to work after probationary period shall be considered as regular employee. Tandaan nyo, class, ha? Pag lumagpas na kayo sa period ng 6 months, pwede na kayo magsabi, uy, sabi ng batas, dapat regular employee na ako. Kung wala kayong sinabi na dapat akong ma-terminate or for a just cause, then I am already a regular employee. Ano ba yung just cause, sir? Mamaya i-discuss natin. Okay? Isa-isa. Ano naman ang job contracting versus labor contracting? Pag sinabi mong job contracting, ito yung if the contractor carries on an independent business or undertakes the contract work on his own account under his own responsibility according to his own manner and method, free from the control and direction of his employer or principal in all matters connected with the performance of the work except as to the results thereof, and the contractor has substantial capital or investment necessary in the conduct of business. Okay? Ito yung mga tinatawag, class. Sige, tatapusin ko muna yung labor contracting. Labor-only contracting para ma-distinguish natin. Labor-only contracting is an arrangement where the contractor or subcontractor merely recruits, supplies, or places workers to perform job, work, or service for a principal. And the following elements are present. Number 1, does not have substantial capital or investment. The workers recruited and placed by such person are performing activities directly related to the main business of the principal. Importante yung number 2. Anyway, para ma-distinguish natin. Halimbawa, yung job contract, o yung very, very common. Ito yung mga nakikita nyong manpower services. Pag nakita kayo ng manpower services, madalas to sa ngayon, kasi nung time namin wala ito, nung nagtatrabaho ako sa Jollibee. Yung mga naglilinis, yung mga janitor, Hindi sila empleyado, hindi sila considered employee class. Ito yung mga janitors. Okay? Or yung sa mga malalaking opisina na hindi sila part ng employment. Pero merong kumpanya na ang ginagawa, nag-hire ng manpower para gawin lang yung paglilinis. Okay? So, iba yon, hindi sila part ng employment ng kumpanya. So, makikita nyo yan, madalas ginagawa. Ang sikat sa Pampanga is Romac Manpower. Sila yung nagsusupply ng manpower sa mga Laos Group. Pag may nakita kayo naglilinis, hindi yun empleyado ng Laos, pero empleyado ng Romac na ang trabaho lang ay maglinis. Job contracting ang tawag doon. Kasi specialization nila is maglinis. So, ang manner nun, ang method ng paglilinis, ay responsibility nung contractor mismo. So, ito yung job contracting. O, kumpara nyo naman sa labor contracting. Yung labor contracting class, based on the elements, actually, wala pang kaso ito. But, if i-base natin sa opinion ko, ito naman yung sa Jollibee. Okay, ano yung sa Jollibee? Kasi ngayon, wala nang direct hiring ata ang Jollibee. Ang ginagawa nila, labor contracting. Ang nagsiset or nagpapadala is isang independent contractor na nagre-recruit at nagsusupply ng mga workers to perform job or work or service for the principal. Kaso, sabi rito, ang importanteng elemento ng ating labor-only contracting para ma-distinguish natin yung workers recruited and placed by such person are performing activities directly related to the main business of the principal. So kung nagpadala ka doon ng cashier, nagpadala ka ng waiter, nagpadala ka ng assistant sa kitchen, directly related to sa business ng principal. Kaya ako sinasabi ko sa mga fast food restaurant na gumagawa niyan, ang tawag dyan, labor contracting. Well, that is only my opinion. Okay? Anyway, wala pa kasing Supreme Court decision regarding that matter. Ibig sabihin, siguro natatakot pa yung ating mga crew ng ating mga fast food regarding that situation. Okay? Now, ano pa? Rights of the contractual employee. Ito, importante ito, class. I will have to discuss this one by one para mas madali nyo nang maintindihan. Okay, ano ba itong mga karapatan na to? Okay, pag sinabi mong rights, siyempre, kailangan isa-isahin natin. Rights of the contractual employee class, ito yung nasa Department Order number 18020 series of 2002. Alam ko yun. Okay? Ano ba yung mga rights na yun? Safe and healthful working conditions. Labor standards such as service incentive leaves, rest days, overtime pay, holiday pay, 13-month pay, separation pay. Ibig sabihin, class, kahit na kayo ay contractual employee pa lang, dapat meron na kayong service incentive leave. Dapat bigyan din kayo ng rest day. Dapat bigyan kayo ng overtime pay. Dapat bigyan kayo ng holiday pay, 13-month pay, at separation pay. Okay? Kasama na din ang Social Security and Welfare Benefits. In fact, kasama din dyan ang pagbabayad ng taxes. Titingnan nyo, class. So, kahit na kayo ay contractual pa lang. And, of course, kasama dito ang self-organization, collective bargaining, and peaceful concerted action. And, siguro hindi nakita, kasama dyan ang security of tenure. Naputol yata yung aking slides. Kasama dyan, class, letter E, security of tenure. Ibig sabihin ng security of tenure, class, hindi kayo basta-basta aalisin kung walang just cause. Okay? Yun lang yun. Pero pag sinabing meron dahilan para tanggalin kita, then wala na yung security of tenure mo. Lalo na kung contractual employee kayo. Okay? Next. Uh, labor standards. Ano yung statutory workers benefits? Ibig sabihin ng statutory, ito yung binibigay ng batas. Hindi pwedeng baguhin, hindi pwedeng mawala. Because the law is very, very clear with regard to statutory workers benefits. Okay? Number 1, minimum wage. Pag sinabi niyong minimum wage, ito yung wage order na binigay para sa private sector workers and employees regardless of their position, designation or status, and irrespective of the method by which their wages are paid. Okay? So, very clear yan. Minimum wage. Binibigay yan ng batas. O, itong dapat minimum wage. Itong per hour ng isang empleyado. So, ano lang yung hindi kasama dito, class? Kasama dito yung household tsaka domestic helpers. Pwede yung hindi minimum wage. Ito pa, workers and employees in retail service establishments regularly employing not more than 10. Okay? Pag not more than 10, pwedeng mas mababa ang sweldo kaysa sa minimum wage. Ibig sabihin, sobrang liit na ng negosyong yon. Number 3, workers and employees of distressed establishment when exempted from compliance for a period fixed by the board. Okay? Pag sinabi niyong board, class, ito yung nasa labor. Ano pa? Workers and employees of other firms or employers as determined by the board when exempted from compliance for a fixed point. Kailangan fixed lang. Number 2, holiday pay. This benefit shall apply to all employees except those of the government. Pagkasama sa government, yung holiday pay. Those of retail and service establishment regularly employing less than 10. Domestic helpers and persons in the personal service of another managerial employees. Hindi kasama sa holiday pay yan. Field personnel and other employees whose time and performance is unsupervised by the employer, including those who are engaged in a task or contract basis and purely commission basis. Class, ito yung mga salesperson, ito yung mga medrep, class, hindi yan nakakatanggap ng holiday pay. Premium pay refers to the additional compensation required by law for work performed within 8 hours on non-working days such as rest day and special days. Again, this benefit applies to all employees but not to government managerial. Hindi nakasama ang managerial dyan. Officers or members of the managerial staff, if they perform status or duties and responsibilities na hindi naman ang kanilang direct performance is policies ng kanilang management. Okay? Overtime pay, ito yung overtime work is beyond 8 hours a day. Okay? Sino mga entitled ulit dito? Lahat ng empleyado is entitled. Okay? Next, pareho. Kung entitled ang ikaw sa premium, entitled ka rin sa overtime pay. Okay? Ano pa? Night shift differential. Ito, importante ito, class, pag narinig nyo. Okay? Night shift differential is the additional compensation of 10%. Additional 10% of an employee's regular wage for each hour of work performed between alas 10 ng gabi, 10 p.m. and 6 a.m. alas 6 ng umaga. Night shift differential. Sino hindi kasama rito? Government employees again, except employees of retail and services establishment employing not more than 5. Domestic helpers, hindi rin kasama. Managerial tsaka field personnel. Ano naman ang service incentive leave? Letter F. Every employee who has rendered at least 1 year of service is entitled to service incentive leave for 5 days with pay. Okay? So may bayad yan, parang leave yan. Sino ang kasama? Sino ang hindi kasama? Government employees, domestic helpers, managerial, field personnel, or those already enjoying this benefit. those already enjoying vacation leave with pay of at least 5 days, and those employed in establishments regularly employing less than 10 employees. Okay? So, hindi na sila pwede niyan. So, maganda yan, class. Pagtandaan nyo, pag naka 1 year ka, entitled ka na sa 5 days leave with pay. Service charges, sharing. Ito naman ay ito syempre kasama sa inyo to. This is very, very important dahil ito ay kasama sa inyong trabaho as hospitality and tourism sector ng ating gobyerno. Employees of employer collecting service charges are entitled to an equal share in the 85% of the total of such charges except managerial employees. Tandaan nyo, class. Service charges, 85% dun sa total na nakokolekta. Kung nagcha-charge, class, tandaan nyo ha, kung nagcha-charge ang inyong restaurant ng service charge, kayo ay allowed to get 85% ng service charge. Lahat kayo, tas i-divide yon. The remaining 15% may be retained by the management to answer for losses and breakages and for the distribution to managerial employees at the discretion of the management in the latter case. Service charges are collected to most hotels and some restaurants, nightclubs, cocktail lounges, among others. Kaya importante sa inyo, malaki yan. Pero I think right now, class, 100% na yan. Okay, we have to double check. Meron yatang bagong nilabas na bata. Yata pa ako dito ha, yata pa. But so far, service charges 85% mapupunta sa employees, 15% mapupunta sa discretion ng management. Okay? Ano pa? Separation pay. Okay, separation pay is given to employees in instances doon sa wherein entitled dun sa mga natanggal sa trabaho. Okay, ano ba yung mga tanggal sa trabaho? For just and authorized cause, pwedeng magbigay ng separation pay. Depends on the reason or ground of the termination for his services. An employee may be terminated for just cause. O, kagaya yan, halimbawa, gross and habitual neglect of duty, fraud, or commission of a crime, and other similar causes as enumerated under Article 282 of the Labor Code, and generally may not be entitled to separation pay. On the other hand, where the termination is for authorized cause, separation is due. Okay? Ulitin ko ha, pag yung termination is for just cause, hindi ka pwede ng separation pay. Wala kang separation pay. Pero pag authorized causes, meron kang separation pay. Retirement pay. Employees shall be retired upon reaching the age of 60 years old or more, but not beyond 65 years old. So, 60. Dapat, ito ay mag-a-apply lang sa government or employees of retail services and agricultural establishments or operation regularly employing not more than 10 employees. So, pag more than, dapat meron na. Pag government, may sarili kasi ang gobyerno. Sa gobyerno, 65 ang mandatory. Pero pwede ka na mag-retire ng 60. 13-month pay. Oh, ito, walang ano to. Napakaganda. All employers are required to pay their rank and file employees regardless of the nature of their employment. Dahil nyo klasa, dapat magkakaroon kayo nito. And respective of the method by which their wages are paid, provided they work for at least 1 month during a calendar year. Pag nagtrabaho ka, tinabot ka ng 1 month, automatic na yun. Magkakaroon ka ng 13-month pay. Pero may computation yun, class. Kaya huwag kayong excited. Hindi siya 13-month pay. Kung 13-month pay siya kung naka 12 months ka. So, ibig sabihin, 12 months plus yung 1 month salary mo, kaya 13-month pay. Pero kung naka 1 month ka lang, 1 month salary mo, divided by 12. Okay? I-divide ng 12 yun. Yun yung makukuha mong 13-month pay. Maternity benefits for females, all female employees, whether married or unmarried, you are entitled to 60 days Kung ito man ay normal delivery, abortion, or miscarriage. Pero kung ikaw ay cesarean section delivery, 78 days. Okay? Tapos, merong yung 100% of the coverage daily salary credit. So, pag ikaw ay babae at nabuntis. Paternity. Paternity leave is granted to all married male employees in the private sector regardless of employment. The purpose of which is to allow the husband to lend support to his wife during period of recovery or in the nursing of her newborn child. Employees of the government sector are likewise entitled to the paternity leave benefit. They shall be governed by the civil service rules. O yan, no? Kasama. Class, kung napapansin nyo ang difference, no? Sinabi doon sa female, married or unmarried. Sa lalaki, dapat married. Okay? Dapat kasal. Now, letter M, benefits under the Employees Compensation Program. The Employees Compensation Program is the tax-exempt compensation program for employees and their dependents. Anong coverage ito? All employees in private and public sector regardless of the nature of employment. Tapos, ano pa? Every employer with at least one employee regardless of the capitalization and type of business. Kasama kayo dyan. So, lahat yan ng employees. Pwede nyong makita yan sa ECC, ang tawag dyan, Employees Compensation Commission. Makikita nyo doon kung papaano yung ano yung makukuha yung benefits, lalo na yung mga na aksidente, meron yan. And of course, the benefits under the Social Amelioration Program. Ano bang, ano rito? Ito yung presidential decree to kinreate pa to ni Ferdinand Edralin Marcos nung panahon niya. The program was formally created, providing the mandatory stabilization of 1 peso per pikul, otherwise known as the Social Amelioration Bonus and the Socio-Economic Projects for Sugar Workers. Siyempre, sugar workers lang yan. Okay? So, these are the statutory workers' benefit under our labor standards. Meron pa tayong dapat malaman? Meron pa. Ito na yung importante. Requirements for a lawful dismissal. Okay? Class, there are 2 requirements. Dalawa lang. Dapat may just cause or authorized cause. Tandaan nyo, ulitin ko. Hindi pa pwedeng magtanggal ang employer ng employee kung walang just or authorized cause. At ang number 2 na importante, observance of due process. Ano ba yung due process? Notice and hearing. Okay, let's go one by one. Just cause or authorized cause. Just cause, Article 282 of the Labor Code of the Philippines. Ano-ano ang mga nakalagay doon? First, serious misconduct or willful disobedience by the employee of the lawful orders of his employer or representative in connection with his work. Serious misconduct. Okay? Ano yung mga serious misconduct na yon? Marami yun, class. Pwedeng nagnakaw, kumupit, willful disobedience, inutusan ka, hindi ka sumunod. Class, tatandaan nyo ang hindi pagsunod, dapat lawful yung order. Kung hindi lawful, hindi yun, pwede kang hindi sumunod. Kung sinabi ng boss mo, sakalin mo yung kaopisina mo, lawful ba yun? Hindi. Kung hindi lawful, pwede kang hindi sumunod. Hindi ka pwedeng tanggalin. May laban tayo doon. So, yun ang mga just cause. Letter B. Ano pa ang just cause? Gross and habitual neglect by the employee of his duties. Class, pag tinignan nyo, gross and habitual. Madalas. Okay? Gross, grabe. Grabe at madalas na ginagawa. Grabe, parati kang late. At bukod sa parati kang late, tulog ka parati sa trabaho. So, pwede kang tanggalin. Letter C, ano pa yung just cause natin? Fraud or willful breach by the employee of the trust reposed in him by his employer or duly authorized representative. Fraud or willful breach. Halimbawa, trabaho mo ay pirmahan o ikaw mag-submit ng mga documents Ikaw ang, ano man tawag doon? Records keeper. O, paano ngayon yan? Yung mga records, ginugulo mo, o kaya tinatago mo, or pino-forge mo yung pirma, pwede kang tanggalin doon. Just cause yun, class. Letter D, ano pa yung pang-apat na just cause? Commission of a crime or offense by the employee against the person of his employer or any immediate member of his family or his duly authorized representative. Ayan naman common yan, class. Commission of crime. Ano yun? Sinapak mo, sinaksak mo, tinadyakan mo. Sino? Yung employer mo, kaya yung mga kamag-anak. Immediate. Okay? Tapos, other causes analogous to the foregoing. So, kung merong kahawig nun, pwede mo nang tanggalin. Just cause yun. Okay? So, ano naman ang mga authorized cause, class? Letter B is Article 283 of the Labor Code. Authorized causes for termination are basically management prerogatives derived from ownership of property and the rationale of business enterprise, which is the maximization of profits. Of course, the state recognizes these prerogatives but regulates them in the exercise of its paramount police power. Hence, while these are valid causes for termination of employment, they are subject to legal requirements regarding procedure and separation pay. May separation pay pa rin at may procedure pa rin. Ano-ano ba mga authorized causes natin? 5 yon. A. Reduction of personnel due to installation of labor-saving devices. Letter B. Reduction of personnel due to redundancy. Letter C. Retrenchment to prevent losses. Closure of establishment or cessation of operation. That's letter D. And disease, pag may sakit. Letter D, ulitin ko lang, tatagalugin natin. Letter A, reduction of personnel. Pwedeng bawasan dahil naglagay tayo ng machine. Diba? Pag may mga machine, nawawala yung mga tao ngayon kasi napapalitan ng machine. Letter B, reduction of personnel due to redundancy. Pag nagkaroon na ng paulit-ulit, nagmumultiply na yung there's already may nagtatrabaho nun, hindi mo na pwedeng gawin ulit kasi meron na nakaupo sa pwesto. So, nagdodoble yung trabaho. So, isa na lang. Tatanggalin ka na. Pwede na. Retrenchment to prevent losses. Pwede magbawas dahil nalulugi. Letter D, closure of establishment or cessation of operation. Nagsara na yung kumpanya. Siyempre naman, pag nagsara, alangan naman. Diba? And disease. Okay? But class, more importantly, dito sa lahat ng sinabi ko, yung observance of due process, class. Due process, notice and hearing. Kailangan merong 30 days notice at hearing. Dapat sasabihin sa'yo ng kumpanya na, oy, tatanggalin na kita in 30 days. At dahil dito, ito mga reason kung ba't kita tinatanggal. O kailangan marinig ang side mo. Bakit? Ano ba ang dahilan? O, ikaw ba hindi sumusunod sa trabaho? So, ito yung tinatawag nating notice and hearing. 30 days, class. I did not write it there because I want you to listen to the lecture. 30 days ang ating notice and hearing. Okay? Class, remember, ito yung mga tanong. Gusto kayong bigyan ng mga mental calisthenics. What are the normal working hours of an employee in one day? Answer, 8 hours. Is there a definite time when these 8 hours will begin and end? None. A work shift can begin on any hour at the discretion of the management. Siyempre, kung meron kayong mga trabaho na kailangan kayo ang bawa, restaurant, okay, pwede sa gabi yun. Hindi pa pwedeng basta-basta umaga lang na 8 to 5. Does the 8-hour work per day apply to all workers? Yes, it shall apply to all employees, all establishments and undertakings, whether operated for profit or not. Is it possible for the 8-hour work a day to be rendered on staggered basis? Answer. Yes, nothing in the law prohibits 8 hours being rendered on a staggered basis, provided the 8 hours are within the 24-hour period. Okay? This practice, however, is not usually done for practical reasons. Plus, ito yung mga minsan ginagawa ko to sa restaurant, lalo na pag meron tayong mga tinatawag na off-peak. Off-peak, pag hindi malakas. Halimbawa, ang schedule ng empleyado ko, 8 to 12. 8 to 12. 4 hours of work. O, tapos mag-break siya. Pasok na lang ulit siya ng 4 to 8. So, total of 8 hours. So, may 4 na oras siyang break. Okay? What shall include compensable hours of work? The following shall be considered as compensable hours of work. All time during which an employee is required to be on duty or to be at the employer's premises or to be at a prescribed workplace. All the time during which an employee is suffered or permitted to work. All time during which an employee is engaged to wait by the employer. So, kasama yon. Lahat yon. Bigyan natin example. There are cases when a worker in the course of performing his job may spend hours without really doing anything, like a company driver who is made to wait between trips. Is the time spent for waiting compensable? Answer. Yes. This waiting period shall be considered as working time since waiting is an integral part of his work and he is engaged by his employer to wait. How about a worker required to remain on call? An employee who is required to remain on call in the employer's premises or very close to that, he cannot use the time effectively and gainfully for his own purpose shall be considered as working while on call. Kasama pa rin yun, nagtatrabaho pa rin, ibig sabihin. Okay, how much time is a worker allowed for lunch break? Not less than 1 hour. However, this is not compensable. Okay? How long are break periods? Rest periods run from 5 to 20 minutes. These are considered part of working time, therefore compensable. Class, tandaan niyo yung mga sinasabi ko, tinatanong ko ha. Okay. Can workers work less than 8 hours a day? Yes. At the discretion of the management, since the law does not preclude the employer from granting to its employees shorter work hours than that of provided by law. Is it possible that the lunch break may be less than 1 hour? Oh yes, under the following cases. The work is non-manual in nature and does not involve strenuous physical exertion. The establishment regularly operates not less than 16 hours a day. The work is necessary to prevent serious loss of perishable goods. In case of actual or impending emergencies, or there is urgent work to be performed on machineries, equipment, or installation to avoid serious loss, which the employer would otherwise suffer. Okay? Ano pang gusto nyo mga tanong? Yun na yun. Okay? Ang minimum wage naman, depende yan sa taon at saka depende yan sa mga dumalabas na batas. Kaya ako sinasabing depende yan sa taon class, syempre, mas mataas na ngayon ang ating minimum wage. Okay? So, application, depende na yan kung saan kayo papasok, kung restaurant or hotel. Thank you very much and watch out for label